Statute law and common law are fundamentally distinct in their origins and how they are created. Common law arises from the judiciary's authority and independence to create laws through due process. Judicial decisions from superior courts are binding on the lower courts. This is known as the doctrine of precedent. Over time, many principles from common law are codified into statute law. Both state and federal parliaments are endowed with the power to create statute law as outlined in their constitution. Statute, at first glance, is created as a bill. This bill must undertake a number of steps within the House of Representatives and the Senate prior to becoming enforceable law. Laws pertaining to Kayla's matters. Kayla seeks to establish whether she has standing to initiate a civil action in the tort of defamation. The relevant legislation is the Defamation Act 2005, Western Australia. The case of FJ v. Sidlin is a like case that will serve as relevant precedent. Secondly, Kayla seeks to clarify whether she has committed the crime of grievous bodily harm. The relevant legislation is the Criminal Code Act Compilation Act 1913, Western Australia. Section 297 outlines the essential provisions for assessing grievous bodily harm. The case of O'Day v. Western Australia will serve as a relevant precedent in these matters. Federal versus state legislation. The key difference between federal and state legislation lies in their jurisdictions. Federal powers are derived from the Australian Constitution Act 1900 Commonwealth, specifically Section 51. In contrast, the states have powers to legislate in other areas such as roads, education and criminal law. Section 109 of the Constitution addresses conflicts between Commonwealth and state laws, stating that if a common law contradicts state law, the Commonwealth law prevails, rendering the state law invalid due to its inconsistencies. This short video is here to help demonstrate how to access legislation. Firstly, open up your web browser and type in WA legislation. Click on the link. Then open up the web page and you will see in the top left corner the words Acts in Force. Click on this link. Then open up the page and you will see the alphabet. The relevant letters that we're looking for today is C and D. Open these and then scroll down to the relevant legislation such as the Defamation Act or Criminal Code. To assist Kayla with her criminal matters, we need to turn our attention to the Criminal Code Act Compilation Act 1913 Western Australia, particularly 297. This section addresses grievous bodily harm and its subsequent penalties. To interpret this provision correctly, we need to start with a purposive approach by examining the Act's true nature, that being to codify criminal law in Western Australia. Section 297 states, any person who unlawfully does grievous bodily harm to another is guilty of a crime and is liable to imprisonment for 10 years. We can see here that grievous bodily harm is described as a crime. To establish what a crime is, we can refer to section 552, subsection 1 of the code. This provision states that anyone who is guilty of an indictable offence is guilty of a crime. Indictable offences generally carry a sentencing penalty, and we can see that the penalty here is for 10 years. To confirm that we are in fact dealing with an indictable offence, we can refer to section 3 subsection 2 that states indictable offences are trialable, meaning heard before a judge or a jury. And it is only the district or the Supreme Courts that hand down sentencing. Now, let's apply the literal rule and look at the key words to establish guilt beyond reasonable doubt. While terms like any person and unlawful are clear, the words crime, grievous and bodily harm require further interpretation. Breaking down the provision will help us paint a clearer picture of what Parliament intended when they incorporated this provision into the code. Luckily, we can refer to the extrinsic materials in section 1. The code defines grievous bodily harm as any injury that endangers life or is likely to cause permanent health issues. If we are to establish that Kayla is guilty of this crime, we need to ask her 3 questions. 1. Did her actions cause bodily injury? 2. Did that injury endanger another person's life? Or 3. Is it likely that the act caused a permanent injury to another person's health? If we revisit the facts for more context, Kayla has admitted to assaulting her father by punching him in the eye. This resulted in permanent damage to his eyesight. Since the eyesight loss is considered permanent, it is likely that Kayla's actions could be categorised as the indictable offence of grievous bodily harm. Specialist courts at the lowest level in the court hierarchy. The state tribunal is not necessarily as formal as a court, however, it holds jurisdiction to hear matters regarding government decisions, and on appeal, matters will be heard in the Supreme Court of Western Australia. The Coroner's Court holds civil jurisdiction to investigate reportable deaths. The Children's Court hears criminal matters involving children aged 10 to 17 and civil matters to do with protective applications for children under 18. The Warden's Court is another specialist court that hears civil matters related to mining. The major West Australian courts. The Magistrates Court holds the jurisdiction to hear summary criminal offences and civil claims between $10,000 and $75,000. The District Court is a trial court and holds the jurisdiction between the Magistrates and Supreme Courts to hear serious indictable criminal offences and civil claims between $75,000 and $750,000. The Supreme Court of Western Australia has original jurisdiction to hear the most severe of criminal offences and civil claims above $750,000. The appellate jurisdictions. The District Court, Court of Appeals, has appellate jurisdiction to hear civil matters from lower courts in Western Australia and the Criminal Injury Compensation Assessor. The Supreme Court, Court of Appeals, holds jurisdiction to hear both civil and criminal matters on appeal from the Supreme Court, the Administrative Tribunal, and from the District Court of Appeal. The federal court system shares first instance original jurisdiction with the Supreme Court of Western Australia. The Federal Circuit Court has jurisdiction to hear civil and constitutional matters in Western Australia. The Family Court of Western Australia holds the authority to hear both state and federal family matters. The full court of the Federal Court will hear matters from the Circuit Court and the Family Court to provide determination or appeal. The High Court is the highest court in its original jurisdiction, and its full court decisions are binding on all lower courts within the Commonwealth. Which court is likely to hear a case in defamation? Defamation cases are generally brought to proceedings in the District Court of Western Australia. This is because the court awards damages between $75,001 to $750,000. If Kayla is seeking more than $750,000 in damages, she may apply to the Supreme Court. However, the amount she seeks must be approved by the court registrar first, and it must be made within 12 months of Eva's alleged statement. The role of the judge. In both civil and criminal cases, a judge must act impartially and apply the law to the facts presented. Judges can question evidence during voir dire and guide juries to reach a verdict. In criminal cases, judges must impose sentences, while in civil cases they award damages. The role of the parties and their legal representatives. Australia's common law operates on an adversarial system, where two parties present their disputes before the court. In civil cases, the complainant is known as the plaintiff, and the other party is known as the defendant. In criminal cases, the Department of Public Prosecutions initiates proceedings. Legal representatives serve as advocates for their clients, providing legal advice, assisting with document filing, and representing clients in court, while upholding integrity and confidentiality as mandated by the Legal Profession Uniform Law Application Act of 2022. The burden and standard of proof in civil and criminal cases. The burden of proof is a key principle in Australian law. The party bringing a case must prove their claims. In criminal law, the prosecution must establish guilt beyond reasonable doubt, preserving the defendant's presumption of innocence. In civil law, the standard is on the balance of probabilities, meaning that the scenario must be more likely. The importance of strict rules of evidence and procedure. In Western Australia, the tendering of evidence is evaluated under strict rules guided by the Evidence Act of 1906 in Western Australia. Evidence is considered relevant if it logically connects to an issue and helps prove or disprove a fact. Essentially, relevance means that the evidence can support or challenge the fact. The low threshold test states that so long as evidence is authentic, credible, persuasive, and holds probative value, the evidence will be deemed relevant, unless there is a specific rule for exclusion. Evidence will also be deemed inadmissible if it is irrelevant and holds no connection to the fact at issue. If evidence is found to be unreliable, confusing, unlawful, hearsay, or presumptive, it will also be deemed inadmissible at law. The trial judge has the discretion to determine evidence admissibility during voir dire. Evidence must hold enough weight to assist the jury to logically connect the material facts to the issue in order for the court to come to a final determination. The appeals process. Both of Kayla's matters, civil and criminal, will be appealed to the Supreme Court, Court of Appeal of Western Australia. An appeal is initiated on the grounds that the deciding judge has made a legal error. The process for applying for an appeal for criminal and civil matters is similar. However, it is different due to the judgments being based on either convictions or awards for damages. The following table outlines the appeal steps, along with the relevant legislation and court rules. Criminal appeals have a distinct requirement. The Director of Public Prosecutions must be consulted regarding Kayla's appeal. Should the appeal be granted, the court possesses the authority to quash the original conviction and issue a certificate to the District Court to communicate this decision. In contrast, in civil matters, while the parties are permitted to respond, the court outcome will differ. Judgments will be delivered in the form of directives and orders, which may necessitate a rehearsing of the original trial. Generally, once the matter has been heard in the Court of Appeal, a decision is reached immediately. Jury duty. In the event that Kayla initiates legal proceedings against Eva, there is no established requirement for a duty to preside over the matter. While juries are typically mandated in criminal cases, Section 51 and subsection 1 of the Juries Act 1957 Western Australia states that a Supreme Court judge may, on the application during a civil trial, grant an order for 2 or more jury officers to attend court at the expense of the applicant. It is important to note that jury duty involves the random selection of Australian citizens who are enrolled to vote in parliamentary elections. When an individual receives a summons to serve on a jury duty, compliance with this summons is a legal obligation as stipulated in Section 4 of the Juries Act. Should an individual neglect to attend court without a valid exception as outlined in Section 5 of the Juries Act, Section 55 specifies that significant financial penalties may be imposed.